get to those today?
I hope so.
Ask Ruth
I have a few questions.
for a laptop.
Stand,
I
stand,
was
stand.
told
Yeah.
informally that
Lowercase.
we
Stand,
probably
stand.
weren't going to get there.
Lowercase, yeah.
What? The code
Okay, it's 2 o'clock. Are we live? Okay. I'm not sure this is. Okay. I'd like to call this meeting to order of the Rehoboth Planning Commission today, November 14th at 2 o'clock, and ask the city secretary to call the roll, please.
Commissioner Dewey,
Present.
Commissioner Ellison,
Present.
Commissioner Gay,
Here.
Commissioner Hunter,
Here.
Commissioner Strange,
Here.
Commissioner Stewart,
Here.
Commissioner Stockdale,
Here.
Commissioner Davis is here, Commissioner Bryan.
Here.
Chair.
All right, I'd like to welcome several new members, if we could. Earl Stockdale, could you introduce yourself, please, sir?
Hi, I'm Earl Stockdale, and I am brand new. This is my first meeting. I am retired, but working as a consultant for a firm in Washington, D.C., and formerly with the Corps of Engineers and the Department of the Army for 42 years, where I was the Deputy General Counsel of the Army and the Chief Counsel of the Corps of Engineers.
Welcome, sir. Susan Stewart.
Hi, my name's Susan Stewart. I'm a full-time financial advisor and non-practicing lawyer, and I'm happy to be here. Thank you.
And Susan Gay.
I'm glad to be back. What can I say?
Thank you. Ms. Womack, would you verify the meeting notice, please?
Okay, before I do that, everybody needs to have the mics right at their mouth.
Is that better?
Yes.
Okay.
Okay, the agenda was published and posted in City Hall and on the city website, city portal on November 7th. It was amended and reposted on November 10th. And it was sent out from the portal the same days. The public notice for partitioning application 0922-01 for the properties at 7, 9, and 11 Cookman Street was posted in City Hall on October 24th and also was posted on the portal. The ads were sent to the newspaper for publishing on Friday, October 28th and November 1st in the Cape Gazette. November 2nd in Coast Press. And October 27th and 28th in Delaware State News. Notification was sent to property owners within 200 feet of the subject property, and signage was posted. That's all I have, Chair.
All right, thank you. And the, under correspondence, you have several emails listed here. Have they been made part of the amended agenda?
The emails that came in over the weekend and
Oh,
this
okay.
morning
I'm sorry, no.
are in your packets, but I've not been able to embed them.
Got you. But they will be after this meeting?
Yes.
All right. Okay, our first agenda item is considered old business. It is a public hearing of partitioning application 0922-01 for property. It's basically lots 7, 9, and 11 on Cookman Street. And the request is to create out of those three, 2 lots, one of 6,285 square feet and the other of 6,277 square feet. The applicant present, Mr. Dukes. Welcome.
Good afternoon. This is the final phase of the preliminary hearing. It was held about a month ago for the petition of my clients. My client here, Andres Termales, is here, and he's one of the representatives. The land is owned by Pomard Investments, a Delaware limited liability company. The property has been identified as being on Cookman Street in the City of Rehoboth Beach. You have jurisdiction over those lots, of course. And as far as the record's concerned, there was some discussion sometime last month about whether it's a partition or whether it's a subdivision. And Mike brought something up before the meeting and said that they'd like to consider it a subdivision rather than a partition. The Planning Commission has authority over both of those actions by 51.08 in the code. And so if we're going to call it a subdivision is directed by your attorney and Mike, we were applying under 236.7A, which would be the titled owner is here, and he is going to make a statement that he's going to ask for a subdivision. Is that correct, Mike?
Yes, sir. There seems to be some question, or at least a bit of confusion in the records, and that included looking at how things stand record-wise up through today. The application that was filed contains an exhibit that shows lots 7 and 9 as one single lot with a structure presumably in the center of it, it looks like, and then lot 11 as a separate lot. And so the question was, are we dealing with two lots, 9 and 11 being one lot, and lot 11 being a second lot, and then moving a boundary line to create two lots of different size? Or the question is whether lots 7 and 9 are actually two separate lots. And we determined today that the city taxes those two lots as two lots. And so that might best fit under the definition of a minor subdivision as opposed to a partitioning. And that's been the question here today. And so the standards, as I understand from what my reading of the Municipal Code, are the same. If you meet one, you meet the other. There's a difference in the application fee. And so I believe you had indicated that your client had no objection if this is treated as a minor subdivision as opposed to a partitioning, and that your client would pay the additional, I think it's $1,000 application fee. Is that correct, sir?
Yeah, if that's the requirement, then that's fine.
Okay. We just want to try and follow the rule book, that's all.
Okay. We've followed under 236.9 all of the requirements. Your building inspector, Matt, has made the statements in the preliminary hearing in October that all these things were met. Under 270 of your section, the two lots being established meet all the requirements. They exceed 50 feet of street frontage. They'll be 75 feet each. The existing structures all meet the standards because there's no need to change any of the structures. The structures all fall within all the setback perimeters. The area that's left will be at least a 4,000 square foot rectangle there. Now remember, Cookman Street lots are not 100 feet deep. They are 86 or 87 feet deep. But there's more than enough square footage to meet all these criteria. The lots are all residential, and they're residential on all sides. So therefore, as one of the requirements of this request in 27.22D, it has to match the neighborhood. So these are residential, and your neighboring lots or adjoining lots are residential. I think there's been a number of letters sent in from the neighborhood in favor of this. To my knowledge, there's been no objections at all. We are not changing the zoning. It'll stay the same. And if this, I was going to say petition, but now this subdivision is granted, it'll have no adverse effect on parking in the neighborhood, and it'll have no adverse effect on the neighborhood values. The purpose of this is that my client and their neighbors who are part of this discover there are these really beautiful trees that are literally right in the middle of the lot. And they wanted to preserve the trees, so after general discussion, they decided that they would just go ahead and split the lot in half, and therefore these trees would be literally down the middle of these 75-foot lots. So, and apparently what's the largest tree in the state?
Well,
or county?
apparently, they are some of the oldest trees in Rehoboth Beach, the pine trees. And we want to make every effort to save them.
And finally, and to bring this to conclusion, this does meet the standards established by the comprehensive plan of the City of Rehoboth Beach. And if you folks are obviously have to follow that plan, and it meets all the criteria. So if there's any questions, we'll be willing to answer.
Any members of the commission? Hearing none. Mr. Dukes, in terms of that being it's now been determined to be a minor subdivision, does your client agree that any future filings among the land records, for example, on a plat, that sets up exactly what you've requested here today, if granted, that it would refer to this as a minor subdivision and not as a partitioning?
Basically, it's just semantics. My client has no intention of doing anything but having two nice lots.
Right, okay. Matt Janis, do you have, has there been within the previous 12 months any application for this subject parcel to subdivide it otherwise?
No, Chair.
Or any other partitioning request?
That is correct. No other requests.
Okay. Do you have any issues here today with what, because we did have an earlier meeting about this, and I don't remember any objections from that meeting. Anything else that's come up that might attract your interest?
No, sir.
Okay. All right. Anything further, Mr. Dukes?
No, thank you.
Members of the commission, discussion. Mr. Strange.
Yes, I'd just like to make sort of an overarching comment, and Hal knows this well, that there's a whole series of criteria that we're supposed to use to evaluate subdivisions and partitionings under the code, and not just for today, but for the future. And so I took the time to do that, and I can't find anything that's objectionable in this request. It meets all the criteria from all the various dimensions. And the other thing, which I think is interesting, is I can't remember in the last 11 years where we've had a request that's come before us where there were letters of support where it was 100% unanimous in support of that. Usually there's always been an outlier. But even with those letters were in the form of desires and preferences and not matters of law and facts and evidence. So it's nice that people would like to see this done, but it has to be done in accordance to the law, which it is. And all the factors that we have to consider have been considered, at least in my case when I reviewed all of this. And so it's nice to have a project of this nature that meets all the criteria in every respect.
Anyone else? All right, would you please consider? Oh, I'm sorry.
I just wanted to express my personal appreciation to you all for being concerned about some of the oldest trees in Rehoboth Beach and being willing to go to time and expense to save those trees in a way that also protected your property rights.
Thank you.
Anyone else? I can go ahead and put forth, what we're trying to do is bring some order to how resolutions are adopted by this body so that they can then be appropriately set forth in the record, and however you vote will be pretty much standardized, yay or nay, with some recitals that reflects the facts of what got us to where we are here today. So the proposed resolution would have recitals that says, number one, within the 12-month period immediately preceding the filing of the application, these parcels were not the subject of a subdivision application that was denied by the Planning Commission. Number two, the notice requirements of Section 236-28 of the City Code have been met with regard to the application. Number three, the application meets the definition of of a minor subdivision as defined in Section 236-3 of the City Code. To wit, any subdivision containing not more than 2 lots fronting on an existing state, county, or municipal street, not involving any new street or road or the extension of facilities by the city, and not adversely affecting the development of the remainder of the parcel or adjoining property, or includes any subdivision containing 3 or more lots fronting on an existing state or municipal street, not involving any new street or road or the extension of city or county facilities, and does not directly affect drainage on a county road, and does not adversely affect the development of the remainder of the parcel or adjoining property. The next section, a recital, adjoining property owners and other members of the public did not express specific concerns regarding the application. To the contrary, written letters from 10 property owners located on Kent Street, Park Avenue, and Cookman Street, including 3, 4, 5, 8, 14, and 15 Cookman Street, were received into evidence expressing support for the application, including because the partitioning will lower density and preserve the character of Cookman Street and the surrounding neighborhood. Next, the application meets all the relevant requirements of Chapter 236 of the City Code. Next, the application meets all the relevant requirements of Section 270 of the City Code. Next, the application is approved subject to the following conditions. Within 5 days hereof, the owners shall submit an enhanced fee consistent with the fee schedule for minor subdivisions under the City Code, Section 236-4, and owner shall modify the plat and all other documents filed or submitted hereafter to reflect that this subdivision is considered a minor subdivision under the City Code. This approval with conditions constitutes a final action of the Planning Commission under Section 236-6, and pursuant to City Code Section 236-7, this approval shall expire within 6 months of the date hereof unless the applicant has fulfilled all conditions mandated by the Planning Commission as a contingency of its approval. The Planning Commission may grant one extension of this time period for up to 3 months based on good cause. The subdivision here, if approved, with conditions shall be in accordance with the plans prepared by the owners by Scaled Engineering, Inc., dated August 9, 2022 and August 10, 2022, as submitted to the city. And pursuant to City Code Section 236-9G, a copy of the final plat approved and containing the conditions hereby required shall be filed by the applicant with the Office of the Recorder of Deeds in and for Sussex County within 90 days from the date hereof. A copy of the recorded final plat shall be provided to the Planning Commission, the Board of Assessment, the Building Inspector, and the City Manager, and shall be kept on file by them. If any final plat is not filed within this period, the approval shall expire. The Planning Commission, for good cause shown, may extend the time for filing a final plat for a period not to exceed 90 days. And lastly, this resolution shall take effect upon the date hereof. Is it so moved?
So moved.
Is there a second?
Second.
We'll work on an abbreviated version of that going forward. All in favor, please say aye.
Aye.
And anyone opposed? Thank you very much.
Thank you, sir.
Thank you.
Congratulations.
Thanks.
Thank you very much.
Thank you.
The next matter before us today is consideration and possible decision on request from the Board of Commissioners. Now, this has been referred to the Planning Commission by the Board of Commissioners and have asked us to make a recommendation regarding request on behalf of Richard and Stephanie Marsch, Ocean Venture Properties LLC, to rezone the property at 20663 Coastal Highway from C3 classification to C1 classification. Is there the applicant or a representative here today? Yes, sir. Yes, sir. Welcome.
Attempt to use this fancy machine we have over here.
Okay, now, you have to remember the admonition from the city secretary about the microphone.
Does that cost anything to use this today, or is that? All right. Okay. Thank you. My name is Carlton Savage. I am with Scaled Engineering, principal and professional engineer with that company. Our address is 20246 Coastal Highway. Here today I have Mr. and Mrs. Marsch. They are here to answer any questions you may have on the application and what their potential use for the application may be. The property that we're describing here, I think most of us know the location, the Rehoboth Auto Repair. Some of us probably take our car there for a repair. They run a great business. Mr. and Mrs. Marsch bought the adjacent property. Actually, there's a little strip of land owned by Ocean Bay Mart between these two, but essentially adjacent to this parcel. They purchased it with the intent to expand their business someday, especially with the changes that are happening with the Ocean Bay Mart property. Right now, Mr. Marsch uses a few of those bays in the back. They're actually becoming unusable at the time, and he knows that his future is to expand his operation. The most logical thing to do would be to buy the property next door, which he has done. However, reading the code, we find out there are some limitations to him expanding his business on that property. His current Rehoboth Auto Repair Shop is actually located on C1, and the little strip of land, the alleyway that's between, is also C1. So this parcel 6, which is 334-20.09-6.00, is the subject property. That property is currently zoned C3. So the intent would be to upzone that property to be able to use it similar to what he is using now, which is a repair shop, service and repair shop. The limitations really come down to a few things in the code. So there's very subtle differences between the C3 and C1. I actually had to go through and go line by line to check some of those out. One of the main differences is there are a few uses that are different between the two. Those uses, there's actually 6. Those 6 I'll describe because I think one of the concerns as you look at this application would be what could happen or what could be done on this property. The 6 different uses, number 1 is a theater or a hall, billiards and bowling, tennis courts, gymnasium or health club, undertaking parlor, and commercial garages and repair shops. So as I look at that, really the worst possible use I would consider, unless you're not a health nut, would be the commercial repair shop. So as you consider that today, realize that I don't think there's any use here that can get worse than what we're already presenting. Not that it's a bad use, it's just, I don't think you have to have the fear that the use is gonna be different than what we're describing. That is a huge factor, I think, in making that decision. Also, a difference between the two uses, and also probably the only difference I could find that was pertinent to what we would like to do, is the size of the building. C3 allows up to 10,000 square feet of building size, and the C1 district would be limited to your FAR. So you would only be able to do what the FAR and parking and different things would allow. So Mr. Marsch has no intention of building something larger than 10,000 square feet. His current garages are much smaller than that. His proposal, we understand, would have to come through a site planning process. You would see it again. That process would spell out all the requirements and make sure that everything is code compliant with the site plan itself. Today we're talking about rezoning. So simply, his proposal would be to expand parking, provide additional storage for parts and things to keep it off his current property. He is running out of space. And also, if he had the ability, and I think this is a big part of his current decision, is if he could go ahead and put another repair service bay, that would be the expansion he would need. So parking is allowed, office space, storage, those types of uses would be allowed under C3, but another bay or another service garage would not be allowed as it currently stands. So the request today would be, can he know or does he not know that he can move forward with that approach? So the property, I think we already described it, I don't think I said it, but 20663 Coastal Highway. I'm gonna try to show you your So on this map, this is a 2010 zoning map of the Rehoboth Beach. I believe that's the most recent. This area is along along Bay Road on this map, or as we know it, Coastal Highway. The property in the orange color, darker orange color, is C1. That's the Ocean Bay Mart property, Rehoboth Auto Repair. The purple properties are R1, so that's single family residences. And then the bright yellow, orangish color is the school. So that is the educational zone, I believe. I could be wrong with that. Yeah, educational and residential. And then there are 4 properties that are zone C3 that also front along Coastal Highway. There have been quite a bit of change to those 4 properties over 3 properties over the past few years. The 2 properties to the north has become a combined, I believe that's apartment complex or condos. So they've been combined into one single residential use. That property, although zoned commercial, is now being used residentially, those 2 top parcels. And I have their numbers if we want to look at them closer. Then we have our subject property, which is the most southern of the 2 on that map, on the second group of 2. And then the property just adjacent to the north has actually been subdivided and is known as, that was basically into 3 single-family residences. So all 3 of the other C3 properties here have recently become reused as residential. The only outlying property now is the one that Mr. Marsch and Mrs. Marsch own, and their intent, being contiguous, would to basically convert that commercial use into the C1 district that it adjoins. So the property is contiguous with the C1 zoning. It is harmonious with the other uses, as we would, present this as an extension of the current use. And we see no adverse effect as it comes to that use being there, since the uses already exist in its current location. Then we get to setbacks and bulk requirements. So those types of things do not change between zoning districts. So the C1 and the C3 zone would require the same bulk requirements. There's no setback differences. It's based on the use you put on the property. So your front yard, side yard, rear yard setbacks all depend on the actual, tier of use you're going to put on there. So residential, bigger setbacks; commercial, a little less. Height, same thing, depending on what the use you put on there. So there's no difference in the bulk requirements. There are provisions to protect the residential properties next door. So if you are adjacent to a residential property, such as the R1 zone to the rear of us, you would have to have a 5-yard rear setback with screening. So there's quite a bit of provision there to protect that residential property from the commercial. Differently, the 3 properties that were just subdivided, those are actually in a commercial district. So I'm not sure that applies to those. However, we would love to do it if we don't have no opposition of doing that, should that be required. But I think it's based on the actual district, not the actual use. So in this case, the district would be, so whether we do C3 use or C1 use, that would be the same scenario in both cases. Yeah, so in terms of the FAR, the maximum we'd be allowed to do on this property commercially would be 22,000 square feet. So that would be, and I believe the way it talks about building size, so it's not just 10,000 square feet total. I believe the C3 would be allowed to have two buildings, 10,000 square feet apiece, if possible. But as you can see with this property, our total property size is 11,000 square feet. So getting those types of large numbers just aren't real feasible on this property. So we're not concerned with the building size, but I just wanted to point that out to you guys. That's pretty much what I have. Rick, would you like to add anything? Or?
I think you covered everything.
Okay. So that's all we have. If you guys would like to ask us questions or maybe something we can answer, we'd love to entertain that.
Members of the commission?
Yep.
I have a couple of things. First of all, thank you very much for that introduction of the differences between C1 and C3. I was prepared for us to talk about that, and you did a good overview. Let me correct a couple of things I heard that weren't, and this has nothing to do with your own plans. It has to do with C1 and versus C3 and backing up to residential. So it's not a statement about your plan at all. First of all, you said there was no difference in bulk requirements. I think there's actually a fairly substantial difference in bulk requirements, because while you stated that as a C1 you could go to 22,000 square feet, C3 could only go to 10,000 square feet for a Tier 3, meaning any of those Tier 3 uses, of which there are about 10 or 12 of them. And no, I don't think there could be more. We do have a code that allows only one building on a lot. So no matter what the size of the parcel is, it would be limited to 10,000 square feet, whereas if it goes to C1, something else, not your plan, but something else could ultimately be built there at 22,000 square feet. So that's a correction. So I mean, and to me, that's a difference in bulk right there. But the other thing you mentioned, and I'm glad you brought this up, was the 5-yard rear setback to residential. Absolutely, that's one of the things that protects residential properties. However, those lots were never rezoned residential. And frankly, I think they should be, provided that the residents agree. I mean, we would not want to do it without their approval, obviously. But if they were to be rezoned residential, then they would be protected going forward, no matter what is built there. And I think that's something we ought to consider.
And if I can add just slightly to that, I believe all those two properties were owned by the same family. So the subdivision actually that created those 3 lots was on one plan. Yeah. They actually moved some land, took some land away from this subject parcel. So probably should have done that at that point, is to protect it then. But I mean, we want to be good neighbors. Rick's here, he wants to stay here. So it's those site plan issues I think could definitely come up at a later date. But thank you for correcting that. I appreciate that.
Anyone else?
I have a couple of questions. Thank you for your presentation. I thought it was really very useful. What is the, just in terms of what the size is of a typical, or one of your standard bays, repair bays that are there now in the portion that's existing, how many, theoretically or possibly, how many of those could go onto this lot if you chose to maximize the number?
Would not maximize the number. I would be thinking like 2 at the most. 2 in a storage area, and that would be basically it. That's all we could realistically use on that lot.
What's your current building sizes, do you know?
I believe they're like, the current building sizes are, I believe, 46 by 50.
Yeah. So doing the quick math, that's 2,000 square feet is what his current building size, right around that ballpark.
So 2,000 square feet for each bay.
His current buildings, which his buildings now currently have, you have 3, 3, and 2?
3, 3, and 2 bays, and an office in the other, and the one that has 2.
Yeah, so the most recent building has 2 bays and some office space. And I think if we were to reconsider, he purchased this property after we did that project, maybe we would have reserved that office space to be moved. But now it's there, and it would have to go through the whole process again. So, but I mean, his current building sizes are fairly small. I mean, 2,000, 3,000 square feet. Getting to those bulks of 10 isn't something that we intend to do. We understand you have to consider that. But.
Sure. And then in terms of what is involved in the work that you do at the auto repair shop, in terms of what, could you describe for me in general the environment in terms of noise or chemicals or pollutants or whatever that typically emerge from the work that you do?
So we have waste oil and waste coolant, which is stored in external tanks. They're drained when they reach a certain level. As far as different chemical solvents, that's really not put out in any kind of quantity. It's a spray that's usually captured and ends up in either the oil or the coolant waste. There's also some solvents that are used that are in like a 55-gallon drum For cleaning parts, that would be the extent of, I would think, bad chemicals. As far as noise level, I've never had it checked. Rarely does it exceed, for any duration of time, an ear-shattering thing, but they may use like an air hammer for 5 or 10 minutes on a real stubborn part. And we have ear protection for that, and it's done inside the building, not outside the building. So that kind of reduces any exterior noise you might hear. I've never had any complaints from neighbors about too much noise in the 30-plus years we've been there.
Explain your hours of operation.
Okay, yeah, we're open right now Monday through Saturday, 7 a.m. to 6, but our shop is open. The actual repair shop is 8 to 5, Monday through Friday, 8 to 4 on Saturday. Right now, we're closed on Sundays. Usually, we don't open on Sundays until the summer these days, and that's provisional if we can get enough help to do that.
Right.
Another day.
And when you said that the chemicals you referred to earlier were, drained out of the bins or not barrels, whatever, where they're stored.
Storage tanks.
Storage tanks, thanks. Where are they drained? Exactly how are they drained?
So a truck comes in, sucks them out. They're located outside. They're capped and stored, so there's not a mess exterior. You know, they're pumped in by air pressure, so it doesn't make a mess.
Are those above or in-ground tanks?
They're above.
Okay,
Yeah,
thank you.
all the in-ground tanks were removed years ago because it was illegal to have them.
And are you subject to any sort of local or state or federal environmental inspections or rules and regulations given the materials that you use there?
We don't have anyone that comes by and checks on. Our insurance company does a yearly walkthrough, and if they see something, you know, there's different, they have a checklist, and we go by, and we, of course, have been told the right way to do it, and that's the way we do it. So our insurance makes sure that we do it properly.
Right. So I take it you've never been cited for any infraction of any of these rules. Okay, I think those are all my questions. Thank you.
Anyone else? Ms. Davis?
Excuse me. I have a question about the what's been referred to as the alley between the two properties. As I understand it, it's zone C1, like your current auto repair property, but it bisects your two properties, and it's owned by Baymart. What are your plans for that? Do you have an easement, or do you plan to purchase it? Is that an issue that you're going to have to deal with?
Yeah, it's not for sale. I have talked to him, he's not giving in any way. And as far as doing anything legal to ensure an easement, I have not done anything in that matter. Hoping not to have to, but I can work around it if I'm cut off from it. I don't need to be equal, you know, through. I can come out and go around that easement if I need to.
Thank you.
Yeah, I think that's why we're here. If we know the property could be rezoned, then we can plan for that scenario. If it's not going to be rezoned, then obviously we need to figure out how his operation works, how we move stuff around. So this is a big part of his future planning of the project.
But historically, what have you used that easement area for, if anything?
The alleyway we're talking about?
Yes, sir.
Just driving through, entering and exiting.
But you're not aware of what your rights are to use that strip of land?
I don't believe I have any rights, honestly.
Yeah, I mean, he's obviously, you know, cars can extend over the line, the fictitious line that's there.
I actually lease parking spaces in the rear building for storage from the shopping center now, so I have access to it without any blowback from the actual owner, because I do lease it monthly from him now.
But you lease that road, the alleyway, or the parking lot?
I leased access to the parking lot, which is through that alleyway.
Okay, okay.
So it's not specific. I have a building that we were used to work in that we can't any longer because the building's no longer viable, safe to work in. But mainly parking and access through.
I lost track of how many bays times 2,000 square feet. Can you tell me what's the maximum size of a building that you're planning to build there? What you would not exceed?
I would think 2,200 would be more than I would ever be able to put there. Don't you?
Yeah, I mean, what we said before was there were 3 existing buildings on that current property. The 2 rear buildings, I believe, are almost identical in size. They have 3 bays each, so that's a total of 6. And then the newest building that's closer to the highway has 2 more service bays, like changing oil and things, your tire things in that one as well, I believe. So there's a total right now of 8 bays that he is operating under, and then his office space is in that front building as well. And that office space ends up being 2 stories on one part of it.
So is that 20,000 square feet total?
I
mean,
don't
that's
have
its
it- I
current
don't have it-
operation, but what is it you're planning for the new lot?
We're under 10,000 in all 3 buildings.
Okay.
All the floors, office space and everything.
Yeah. So as you currently see, and I don't have the size of that other property, on that map, you can see it looks.
The lot
much
is
larger.
20,000.
Lot's
About
20,000.
Just over 20,000.
So I mean, almost twice the size lot with 10,000 square feet of building space.
Okay. Now, I've just been reprimanded. Everyone must speak into the microphone
I know, it's
within
always
three
hard.
3 inches. 3 inches is the critical distance. Otherwise, we'll have to sign, you know.
Can we end the meeting now?
Following up on that, is there any access from your property, the property that you would like to rezone, to Scarborough Avenue?
No, there's not.
So is there any use currently where people might be coming from through the subdivision that's adjacent to this property, whether it's in the rear or along the north side? Is there anyone using an adjacent property as a means of access to this property?
No.
Okay. All right, sir.
Mr. Chairman?
Yes, sir.
Questions? Perhaps again, probably for Rick. Did I hear you say that you, when Baymart is developed, you would lose some of what you presently have in terms of your buildings?
I would lose parking mainly
Uh-huh.
at that time, yes. The buildings have already been evacuated. We don't use the building that we actually pay for now, just because of the condition it's in. So it's just parking is all we're using it for now.
And we've talked about the size of the buildings. What about the height?
I would want to do something similar that's on the lot now to match the other buildings. So that height is, I'm not sure exactly, 40 feet or less than 40, 36?
Yeah, so the maximum height allowed would be 42. Right now, his buildings currently don't exceed that. And I don't have the exact height, but what I can tell you how they operate is he's got lifts. So you got like a 12-foot garage door. You go in, they lift up to another area inside the building. Maybe that puts you at 20 feet, and then your roof. So probably around 30, 35 feet right now is what his current operation looks like. But the requirements would say under 42, and I don't think that makes a difference between zoning districts. It's just.
Thank you.
Mr. Chairman?
Yes, sir.
I have a question.
Yes, yes, ma'am.
When was this zoning done that left those properties at C3 that are the subject of this conversation?
Talking about the ones that were turned into houses?
The green ones on here that were not made residential whenever this zoning map was adopted in 2010, and do we know anything about the rationale for keeping them as commercial?
Yeah, they were divided in 2015.
Yeah, they were
Yeah.
divided in 2015, and at that point, the owner said, and it shows how times change, he was concerned that they might not sell, and he didn't want to lose the designation, so he didn't convert it to residential zoning
Right.
at that time.
Right.
And so we have what we have today. It
Yeah,
was
and I-
really the
and-
fear of not being able to sell the lots.
Right. I guess my question was, notwithstanding that, why were they originally left as commercial in this street that's otherwise residential? Do we understand the rationale for that? And
It was at the request of the owner.
no, I'm not talking about the 2015. I'm
Oh,
talking
okay.
about how did these end up originally as green on the map for zone commercial? Do we know? I mean, presuming whoever legislated the zoning at the time had a rationale for that.
I can only imagine the highway had something to do with that. This property has access directly from the highway,
Right.
and without an easement, would continue to have access from the highway. I went back and tried to do some research on when did the uses get adopted. So there was a change in 2006 in which all of these uses got swapped out and put back in. Oddly enough, I'm not sure what the reasoning was between not having a garage in C3, because when you look at them, they look pretty similar until you see a couple random uses. My guess was there was no garages in C3, so maybe that's why they didn't put one in, but that was just my best guess.
Yeah, when the city annexed it in the 60s, it said that's what they were then. So it appears to be just historical, and we don't know why.
And yet, my understanding is that since the whole house was built there, that for 100 years, that has been used as a residential property, right? The Truett house? Right, yeah. Right, yeah, yeah. I mean, because the county property records show it being single-family residential use going back to like 1900.
Mr. Savage, have you checked the comprehensive development plan to see if this proposed rezoning is consistent?
I did not check. I apologize. I would say that the comprehensive plan, I did make comment about that because I knew you guys, when we first submitted this, you were in the process of updating your comprehensive plan. There wasn't much talk about these properties in the prior comprehensive plan, and I apologize, I did not go through and look at the new comprehensive plan, it just got adopted, so.
But no one has pointed out that you are somehow inconsistent with the CDP.
No, I would assume that commercial is what this has been, would be, and would continue to be under both comprehensive plans. So we would be consistent in that regard.
Anyone else? All right, is that your presentation, sir?
Yes, that concludes our presentation.
Yes, thank you. Anyone else to address this application?
We're going to hear from the public, too, right?
Yes, that's right, that's
Yeah.
what I'm saying. Anyone else? Yes, sir. Please come forward, state your name for us.
My name is James Lashora. I live at 1026 Scarborough Avenue Extended, and I have a unique property in the city of Rehoboth Beach for quite a few reasons. Roger Truett's grandmother lived in my house. He grew up in the house that Richard and Stephanie Marsch recently purchased and would like to expand their operations into. The Truetts owned all of Scarborough Avenue Extended and adjoining parcels. I'm not sure for how long, but you know, so the Truetts pretty much sold all of the properties on our street. One of the commissioners asked if there was any connection between Scarborough Avenue and Route 1, Historically, there was. It's my driveway, and the driveway that is on their lot used to connect. They no longer connect, and we now have the vegetative screen across there that was imposed as a result of the 2015 Planning Commission meeting, when the planning commissioners approved the Truett's Choice residential subdivision of 1028 and 1030 Scarborough Avenue extended. They were connected at that time by our driveway. They severed the driveway and, made the, Truett family house separate from the grandmother's house, the property where I now am. So we are, now access to their lot is exclusively from Route 1, and the other 3 lots that were part of that subdivision. Theirs is part of that Truett's Choice subdivision that was created in 2015. The other 3 are now neighbors of mine that have homes that were built according to the R1 city prescription on basically a 50 by 100 lot. My understanding is they were required to do the 3 trees, the 2 parking spaces, the green space, everything that residential homeowners in the city of Rehoboth Beach are required to do who have R1 zoning. That's my understanding. And I'm not even sure if all of them knew they were buying commercial property when they purchased their properties, but I would like to hear from them, to hear their perspective as far as what they were told by their realtors, by their builders, by the city, as far as what their understanding was, what they were buying into in this subdivision. As Ms. Gay mentioned, they probably should have been rezoned to R1 at that time. Most of my neighbors made public comments saying they should be rezoned to R1. Several of my neighbors made comments indicating, the subdivision should not be approved unless and until they are rezoned as R1. But this one lot that accesses off of Route 1 has a little bit of a different situation than those of us that are on Scarborough Extended. My perspective is, and I was disheartened by the comprehensive development plan this morning, I think C3 exists for a reason. I think we need to have different levels of commercial development. Ms. Davis, thank you for your comments about the comprehensive development plan and how we need to distinguish different levels of commercial in our planning, because maybe we don't want to be right next to the car alarms that go off every day. Maybe we don't want to be next to the tow trucks with the beep, 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 beep that drops off the accident, the cars that need to be repaired from the auto accident that occurs at 2 a.m. Or the 6 cars that come in if it's a multi-car crash. Maybe the PA system for 3 bays isn't so bad, for 6 bays isn't so bad, for 8 bays, we start to grin and bear it. They connected the house with their PA system, so they can call somebody to the office, so everybody can hear, when somebody needs to come to the office for a client. And we hear that, and it gets louder with each encroachment, with each increase in the size. It's beginning to be more than it was in the 60s, right? I mean, it's not just 1 or 2 bays. Now we're talking 10 or 12 or something. The number of cars is considerable. The trucks that come and go are large. The volume of used oil is significant, substantial. The amount of used antifreeze is substantial. Should there be a leak or a spill, it causes considerable risk to the people 5 feet away on the other side of the vegetative screen or the fence, 5 feet away. The dog is lapping the antifreeze, 5 feet away. So that's what we're dealing with. I mean, I think C2 and C3 have a reason. This is case in point. As they've already admitted, this is the worst possible scenario, where you have the most undesirable use of the property right up to the line of the R1. I have the R1. I have the line where the C1 comes right up to my property. My neighbors should have been rezoned to R1. I've encouraged them to file an application for R1. I think it would help the commission if you had it right here in front of you. Do we rezone this to R1 like the Truitt's Choice residential subdivision, or do we go with the C1, which is like what it is that the Marshes have on the other side of the alleyway? And the alleyway is as well, I get it. They are extending the C1. They're not skipping C1 to ask for more C1, but it's not adjacent to their property. It's owned by someone else. And I get it. The owner of that property is not someone who is easy to negotiate with or to bargain with or to reason with. He's offended everybody from one end of the state to the other, including the Supreme Court for the second time. But because he is so difficult to deal with, and because we've looked the other way every time there's been a car alarm, every time there's been the smell of gasoline, every time there have been people walking their dogs while they're having their car serviced in our yard because, there's no green space back there where they're having their car serviced. I don't know that we should take the brunt of this as the green space neighbors, as the residential neighbors. The C3, in my opinion, was put there to create a buffer between the R1 and the C1. And there's a lot of C1 space back there. What we have are small residential lots. I would much rather, if I had a choice, and probably if they had a choice, they would choose to do this as well, is to use the existing C1. But it's there on the map. There's a lot of it currently available. I would like to really ask that we not now that we're all residential, and as they pointed out, all of that green that was C3 is now being used residentially, 100% of it, and now to expand the C1 up into that residential is fairly intrusive. So thank you for listening. Thank you for allowing me to speak today.
Any questions of this gentleman?
Yes, Ms. Davis.
Mr. and Mrs. Marsch, I understand from Mr. Carlton's presentation and Mr. Marsch's comments, they said they want to be good neighbors and that they think that they are good neighbors. Have you had any conversations, you or your residential neighbors, any conversations with them as to what they might be amenable to in terms of mitigating or ameliorating the current problems that you've talked about, the car sirens, the PA system, the trucks in the middle of the night, that kind of thing? Because, and the reason I raise this, the application letter indicated that this rezoning was step one of an overall redevelopment plan, with step two, and it came out today, it was acknowledged to be site plan review. And site plan review by this commission can include conditions, and they can be conditions that protect adjacent residential neighbors. but I'm wondering if you've had any conversations with the Marshes about leaving aside site plan review, but just in general, what they might be amenable to doing to address some of your issues and concerns.
In their defense, they are good neighbors. Our neighbors like them. They like having their cars repaired there. You will see that many people defend their business and don't want anyone to touch it or harm it in any way. I mean, they have a lot of friends and a lot of support from Rehoboth Beach and the community. They do what they can, you know, they run a profitable business. We have not felt, I mean, we feel like they do what they can to try to limit the noise, to try to limit the intrusion. It's, you know, it's more just a function of what they do. It's just a function of what their business is, who their clients are, what their clients' expectations are. Like I said, it's, you know, people who come there to have their car serviced, you know, it's hard for him to tell them, oh, don't walk your dog, you know, in our neighbor's yard. It's hard for them to say, you know, don't walk through their yard to get to our property to have your car serviced. You know, it's hard for them to control when the tow trucks drop the cars off or where they drop them off when nobody is there in the middle of the night when the car gets dropped off and the tow truck driver has never been there before. And the other thing is when their operation reaches that scale, then, you know, the loudness of the announcements and the PA system and all of the quantities and volumes and everything is going to be an expected level based on what you all have given them the right to do as a matter of right under the code. I mean, this won't come up in site plan or board of adjustment or some variance or some exception processing. This will be stuff they can do as a matter of right. We will have no leverage to negotiate. We will have no leverage to ask for them to do something differently. And they may not continue to own the property. They will sell it. Someone else will purchase it. And even if the current owners don't build to the limits that the code says what they can do as a matter of right, the next owners will. So C3 is there for a reason. It currently creates a buffer between us, the R1, and the C1, and my position is it needs to stay that way. So thank you.
Before you go, sir, can I ask you a question, please?
Yes, Mr. Bryan, thank you.
Part of your presentation included a reference to an old right-of-way through what I guess was Truett subdivision. Is that what it was called at the time?
No.
Many years ago?
The subdivision did not exist until 2015. So that was an
I'm talking
application
about
that
through
was
the old
done.
original lots that fronted on Scarborough.
Yeah, it was a family and their mother. So they had a driveway that they shared, and the mailboxes were both, you know, for both homes were, you know, I don't know.
But when
what
you,
that
when
went
you
back
talked
to the
about a
40s or
driveway
something.
that led back and connected to this site at one time, but that was subsequently divided, as you put it.
It was
or-
always a private driveway. The only member, you know, of the public that I can think that used it was the mailman, because the mailboxes were on the driveway for those two homes. So the mailman would drive through to deliver mail to those two homes.
Do you know whether or not there is a recorded instrument in the land records that shows that right-of-way?
I do
If
not
there
know.
was a right-of-way. I mean, there may have been a right-of-way by use, or is there one by a recorded instrument? And that's what I'm asking. Do you know if there is, or it was, at least at one time, a right-of-way leading from Scarborough to this property?
I'm not aware of any recorded instrument.
Well,
that
when you
would
said that
provide
it was, you stopped it, did you do that by way of a written document that you signed and put in the land records, or was that just a mutual decision?
If you
by-
look at the agenda and the minutes from the 2015 Planning Commission meeting, there were agreements about what would be done with the driveway at that time when the subdivision was created in 2015. So the Planning Commission minutes have it in there. That's where there's, I think, the most comprehensive information about the driveway and the vegetative screen that was to be built through it, and give me a separate, saleable property, usable property, separate from the one that they have, and to discontinue common use of that driveway between the two homes, because it's no longer a single family that's, parking a car partly across the line this way one week and partly across the line the other way the next week.
But you just don't know about whether or not there ever was a platted right-of-way between those two properties, your property and...
I have not seen it on any of the surveys. There's nothing platted on any of the surveys from either, when we purchased the property, any of the historical stuff from Scarborough Avenue that went back to like 1940, or from, the Truett's Choice subdivision when those two large lots were divided into the four that currently exist in the Truett's Choice subdivision.
All right, thank you, sir. Anyone else?
Yes, I have a question. I wanted to thank you for helping us complete the record as we think about this. I understood clearly your position about maintaining the property in its existing C3 status because of the buffering effect that affords. Julie did refer to the fact that the site plan could impose mitigating conditions. She asked you about whether you had explored doing that with the Marshes. I wanted to press on that just a little bit more. Do you have any sense of the neighborhood for their reactions? In other words, you've given us insight into your feeling, but it's a large community there, and I'm interested if you have any feelings or knowledge of other points of view.
Yeah, here's what I would say, is that in my experience in the city of Rehoboth Beach, from a planning and zoning approach, it's not common to put R1 next to C1. It is something that planning folks try to avoid, having the service station right next to residences. The property they own has 5 neighbors. One of those neighbors is the alleyway, is Ocean Bay Mart, which is C1. The other 4 of us are residential homes, single-family detached homes that were all built within the last 6 years, 6 years. So we're all new homes that have gone through the process of, planting our trees and getting everything approved. And none of us approve of this being done. You say, well, not in my backyard, but this is a property where it's 5 people's backyard. Most properties where you try to do this, it's out on the highway and it's not in 5 people's backyards. Here they have 5 neighbors. And so it's a difficult property to do it with because it's surrounded on all sides by people with varying interests. One of them is here today. He would like to speak, so we have another neighbor's perspective, Mr. Mark Longacre. He lives 2 doors down from me. So if there are any other questions for me, I can answer them. Otherwise, I'll turn it over to Mark, and he can give another perspective on those of us that are having this happen in our backyards.
Thank you.
Okay, thank you.
Yes, sir. Please come forward.
Hi, I'm Mark Longacre, and I live at 1028B Scarborough Avenue Extended. And we bought the property in 2017. I did submit an email. I don't know, maybe that's part of your packet, but I'll talk from that. My wife and I are permanent, and my wife is Carrie Pauley. permanent full-time Rehoboth Beach residents living in an adjacent property to the one we're speaking of. It's one of the green ones that was in the presentation, and the building is directly behind us. We definitely oppose the zoning request. We purchased our home in the subdivided Truett's Choice in 2017. When we purchased our property, we were led to believe that although these properties were Zone C3, they operated as R1. And at some point, these might be changed to R1. And this was communicated to us we saw it in the local papers, by Roger Truett himself, who we bought the property from, some of the neighbors in the area. And really, we feel that was strongly reinforced by Rehoboth Beach during the permitting, approval of our home design, and building of our home. We had the home actually redesigned, the original plans redesigned to reduce the height of our building. We planted 11 trees on the property, and we had to move our shed 18 inches away from the property line. It was put down once, and we had to move it after inspection 18 inches away from the rezoning area property to meet the residential building codes. The house currently on that property has been operating since the 40s as a residential property. I know we're talking about this as, C3 going to C1. I mean, I live there. I'm there every day. I think of it as a house. I don't think of it as a business. There's people that live in there every day. I know the application says that it's a business and it's overflow parking, and it kind of infers in the application that it hasn't been used as a house, since they bought it, and was used as just a temporary office. But there's people living in it every day, and there has been. So I mean, I think of it as a house. So I think of it as changing not from C3 to C1. I think of it as changing from R1 to C1, and that's a big change. That's a real big change. I think it really only operated as a business for a few months during the construction. When they did, when they used it as a temporary office. To me, the overall plan, it would have been much smarter to have that property and build the office there, rather than more bays there. If you wanted that property, yeah, you use that for the office space. Keep it as C3 if you want to expand, but not, rezone the area behind it that isn't even connected to the initial property. I mean, it just doesn't sound like a reasonable plan to me. You have, C1 and C3 separated by an alley that you don't own, and then you're gonna try to, upzone this one and connect them, but they're not connected. It doesn't make sense. You'd have to drive out back on the highway and back in to get there. It just, again, doesn't make sense to me. But yeah, so I think of it as a change to C1 is absolutely a huge change, because I think of that as a house behind me. Roger Truett told me, my mom grew up in that house. I always wanted it to be a house. That's what I thought it was. And I know there were some questions about, did you reach out? I personally, I talked to Carlton. I reached out as soon as this issue came up, and Carlton and I had a nice discussion on the phone, talked about what are the current plans. He said, really there's no plan yet of what would be built there. I told him, gave him my name and number, my email address, said please have the Marshes give me a call at their convenience. We can talk about what they want to do and see, maybe we can come up with some common ground. So that offer's still available. Happy to talk to them.
Any questions for this gentleman?
Yeah, I have a couple of questions. Thank you for your comments, sir. Can you describe any issues that you have personally experienced in terms of noise or environmental issues, or has that been?
Really nothing at all. To me, the issue, I take all my cars there. Chuck and Stephanie, or Christine, yeah, who run it, great people, absolutely great people. That's not the question at all. I mean, I've taken probably 10 cars, different cars there, and they do a wonderful job with them. So, and I'll always continue to do that. They are good neighbors, but the question is, should anyone be able to go from, again, in my mind, and maybe my mind's twisted, but go from R1 to C1, because that's the way I think of this, R1 to C1. I don't think you should be able to do that. But yeah, they're great neighbors. I mean, all my propane there, they run a good business. I think the difficulty is they've been using a lot of this space in Baymart, renting it, and someday that's going to go away probably. Now, what that will be, I mean, will that be residential? That's a good question, or is that going to be C1, or who knows in the future? But I think they've been using that space. If they just want to use, if they just want parking, then parking they can do on a C3, zone. Parking's no issue. It's and I agree with Jim. They are a very good business, and it's not about their business. It's about rezoning that property, and is that right? And I don't think it is. I don't think any area in Rehoboth should be allowed to do that, regardless of if it's a great business or not.
Well, let me press you on the same point that Ms. Davis initially raised, and that is about the possibility of conditions that could be imposed during the site plan review process, which we're not in right now. But, and whether, I mean, it sounds to me like your concern, which I understand, is that the future is unpredictable, and that once it's if it were to be rezoned as C1, then it would open up possibilities that the current owners do not anticipate, in all honesty and sincerity, but it would leave you next to that kind of property. And in general, what is the function of C3 in this kind of situation? And I think the comprehensive development plan suggests that we should be extremely careful in placing C1 next to R1 zone. So I take that very seriously. But I also do wonder if if there could be some possibility of negotiation of conditions or restrictions or other types of agreements that would extend into the future. And so I don't know if I would ask you if that has ever been broached as a topic.
It hasn't, but we certainly would be. I'd certainly, my wife and I would be certainly willing to have those discussions. Again, the concern is that even before we do this plan, the property is worth more, they sell it, and all of a sudden. But yeah, if there were, forward going commitments that would be attached to that property for all time, sure, I'd absolutely be consider talking about that.
Well, I'm not suggesting any particular, time frame or whatever, but I just wanted to ask if that had been explored.
Sorry, I am.
I understand.
Anyone else? Other commissioners?
I would like to press on the question of, in terms of noise or other, you kind of didn't answer that part of the question.
Yeah, I don't. maybe they complain about my noise. But no, certainly there is noise, and it's all noise that's associated with, having an auto repair business. So yeah, you hear the impact guns, you hear, pneumatic tools, you hear things like that. At this point, we've lived there 3 years full time. I mean, I kind of don't even hear it. It doesn't hit me. I mean, we go out on our patio normally in the evening. Yeah, there's no things running. They're typically done, before we'd be out in the yard and things like that in the evening. That's kind of how we use it. Jim mentioned, the tow trucks and things like that. I mean, certainly that unfortunately happens at night, late, and so I'd say that's the one thing that, if I had a magic wand and it could make it go away, I'd make that go away, because there are tow trucks coming at, any hour potentially, and there's the beeping and things like that. But yeah, really, other than that, that's not a huge issue for me. The huge issue for me is just, I think there's a house behind me that people live in, and all of a sudden we're trying to change it to C1, and again, that's to me, that's wow. That's a huge change.
Anyone else of this gentleman? Thank you, sir.
Okay, thanks.
Any other member of the public like to come forward? I do have a letter that that we received. Let's see who this is from. The Hardys, I think, Bonnie and Paul Hardy, who could not attend today. They have owned their properties at 1022 and 1024 Scarborough Avenue Extended since the 1990s. Became aware the Rehoboth Autos plan to upzone their property through a brief article in the Cape Gazette. We have the following questions. One, why were we not, here we go. Why were we not sent a notice of this rezoning? I can respond to that now. This is not a rezoning. This is a recommendation by the Planning Commission. This matter was referred to the Planning Commission for a recommendation. We do not have the statutory authority to rezone. We're not a legislative body, we're an appointed body. Secondly, they feel that any approvals or changes should not be considered until more information is provided about the issues of what's going on this property, what are the plans for the property. So they also mentioned stormwater management, how it affects neighboring properties. And so just wanted to make that part of the record, since I'm not sure that that's in the record yet. Anyone else from the public? Mr. Walls from Wallace Montgomery, do you have any thoughts to share with us?
Excuse me. The CDP really does, the CDP really does emphasize the desire to avoid conflicting land uses, and particularly focuses on, I don't want to use the word nuisance because that's not what I want to imply here, but the type of activities that could diminish an adjacent property owner's peaceful use and enjoyment of their land. From what we've heard here so far, it appears to be that there is significant concern among the property owners in this area that granting a variance or a rezoning rather for this property in question could ultimately result in a diminished use and enjoyment of their property. I think that that perspective, combined with the appearance of other alternative means of addressing the applicant's needs. So the applicant has the need to increase the capacity of their auto store and service. And it appears that this has been one of the path of least resistance, perhaps, and I don't mean to mischaracterize their design as that, but perhaps this is, option one, and there are other options. I would like to see what other options could be further explored that perhaps negate the requirement for a rezoning, and which might also have the added benefit of reducing community opposition to the proposal. I have heard a lot about the larger property owner to the east there. Unfortunately, I don't have context on his history there, but it would, I don't know if I want to know, but it would seem to me that on the surface, there might be some opportunities to explore with that. Maybe they would lead absolutely nowhere, I understand that, but I think that that should be an avenue of exploration before the considerance of a variance, or I'm sorry, a rezoning request.
Members of the commission, any questions for the building inspector? I'm sorry, we won't bother you today. For the planner.
I have one. My recollection of the language in the 2020 CDP is that the concern was separating or maintaining differences between C1 commercial property and R1 property. Unfortunately, the neighbors to this C3 piece of property, their property is still zoned C3. And so you don't have that situation where it's C1 backing into or immediately adjacent to R1. Their property will remain until they request otherwise. Their property will remain C3, and their property will be a buffer between the C1 and other properties in the Scarborough Avenue extended area. So I find this very difficult, frankly, because it doesn't meet the stated concerns of C1 property immediately adjacent to R1 property.
Yes, sir.
Sorry.
Would you like to speak?
I would, if I could, because there is one property that is an exception, and that's my property, because mine is one of the neighbors that is R1, and it does directly, I have a common border with that property. And, mine is the one that was protected from the C3 by the vegetative screen, this panel imposed back in 2015. So that's what Roger Truitt had to do in the event that this subdivision didn't go through residentially and it got developed commercially. The Planning Commission required him to put up a vegetative screen between his property and my property, and that still exists on the line between, across the driveway between
And yet,
mine and
I
theirs.
don't mean to sound argumentative, I really don't, but every other piece of property, residential R1 property, from your property all the way up to Silver Lake, almost, directly borders a C1 piece of property, Baymart, with no buffer, no C3 in between, basically no nothing.
Well, no nothing except sort of the prescription that all those homes were built until the subdivision came along. We all have lots that were 75 feet wide and 175 feet deep. My lot is over 13,000 square feet. My lot is nearly 3 times the size of the C3 lots next to me. So for them to have this right up to their property line, it's very close to their house. For me, it's like I have another whole lot behind me where my garage is, and it's very different for us with 175-foot lots. That provides, there's a built-in buffer there between us and the C1. And I mean, it's a real thing, for quality of life. And yeah, I mean, I'm very thankful I have that buffer. I paid dearly for it. It's expensive in the city of Rehoboth Beach. I sold a house in the city of Rehoboth Beach that, I couldn't get through building and licensing and everything to develop, and do what I wanted to get on this street. We have a house that recently sold for $2.6 million, and people thought they might tear it down on our street. I mean, these lots are coming at a significant price. And yes, we're buying the buffer, but, my neighbors didn't buy that buffer. They got the city prescription with the 5,000 square foot lots. And it's built different than the rest of the street. It really is.
Can I ask a question?
Sure.
Sorry.
Mr. Walls?
The effectiveness of the 5-foot buffer that was installed, how effective would you
The
say that
vegetative
is?
screen?
Yeah.
It keeps people from driving through the driveway that used to be connected.
Okay.
It got big enough that the renters who rented the house prior to when they used it for their office, the renters who were in there still parked in our driveway even after we bought the house because the vegetative screen wasn't quite high enough and they could still kind of drive through. So, but once it grew up, and once we kind of shooed them out a few times and told them we now own this property and you can't park here anymore, they started parking on the other side.
Jim, oh, sorry.
No, please, go ahead.
I have a question.
Sure.
Is your lot residential?
R1, yes.
So you back to C1, but you have a piece of your backyard that this one abuts the C3 property?
Yeah, so we have a number of stakes down our property line because the two big commercial lots used to come all the way to us from Route 1.
Right.
So the big green came from Route 1 all the way to us. And then the one that the Marshes own got narrowed. So all the ones next to us, got deeper to narrow those. So there's I guess our border with C1 no, it didn't change. That's all C3 on that side, and we're just C1 across the back. We're just C1 with Ocean Bay Mart. Yeah.
Anyone else?
Well, Nick, I appreciate your comments about, is there a plan B is essentially basically what you're saying, because one of the things I heard in the presentation is that much of the lot will probably be used for parking and could be now at C3. So really the only difference is these few bays that we want to put in. So it's like they're not necessarily maximizing the C1 use. However, once we get to site plan review, I'm not quite sure how to phrase this because of course I have no idea what would happen in site plan review, but if conditions are put on it, then I guess I would just caution the owners that you may not end up with what you think you're going to end up with. In other words, you're not getting a C1 lot that is open season. You're getting a C1 lot that would likely have conditions. So is it worth it for those small uses, or are there alternatives, as Nick suggested? I guess that would be my question.
Yes, as a planning commission, we're not able to conditionally rezone something or even recommend to conditionally rezone. Ours is just a recommendation to the Board of Commissioners. Anyone else? I personally have some concerns about the potential existence of a backdoor right-of-way, I'll call it, that may be of record. No one seems to quite know. If such a thing does exist, any future purchaser would certainly want to know and may well find a way to utilize that, which I think might disrupt the adjacent neighborhood. I think that's something that's easy to remedy. It's easy to get a title report. There's a fine attorney in the audience here today. I'm sure they could do that. So that may solve that question, at least in my mind. Members of the commission, how would you like to proceed?
I have a question. I was the only member of the Planning Commission at the time when this originally came up 6 years ago. And it concerns me that It concerns me that the current residents the one comment was made that they were advised at the time that these were commercially zoned lots and were not residential lots. I think I heard that correctly. And so they could have known or should have known what they were buying into, what was adjacent to them, and what their lots were currently zoned as. On the other hand, even if it was residentially zoned, anytime a residential zone abuts a C anything, there are potential conflicts. And that creates a difficulty. And I think it's important, as the chair has pointed out, that we're being asked to make a recommendation to the commissioners if they should rezone this, not as a function of the applicants, although we needed to know what the applicant was considering. It is an extremely difficult set of circumstances, both physically with the property, particularly with the other property that is owned by an individual who is not here, a much larger property, and the nature of how these properties have evolved. So I think, as been pointed out by Planning Commissioner Gay, there may be alternatives here as to how this should be considered and the options that are available. But I don't think, based on what we've heard today, that we're in a position to make a determination of, quote, rezoning this to the commissioners. It seems to me that the C1 and the C3, although it may not have worked out as was originally envisioned at some point during the last century, that these were identified as C1 and C3 for a reason. And even though current property owners adjacent to it purchased residential, any commercially zoned property can be used residentially if that's decided. And it's unfortunate if they purchased these lots and weren't aware of that. However, notwithstanding that, I think so far, at least what I've heard, I haven't heard sufficient justification or research to indicate that it should be rezoned from C3 to C1, even though it's rather anomalous in how this thing occurred.
Are you suggesting perhaps that we defer this for a period of time to give the applicant an opportunity to come in and address what the issues that have been raised here today?
I think it would be very helpful to pursue other alternatives that may be out there to achieve everyone's objectives in this case, as opposed to, quite frankly, I wish if we could go back in time. At the time, the request was not made to rezone this property by the property owner because he was very concerned that they might not sell. Well, he couldn't see into the future, and as was pointed out, these properties are extremely valuable now, where 6 years ago he was concerned that they would not be valuable. So I think, yeah, we're not in a position, from my perspective, based on the science and the facts and evidence, I don't think we're in a position to make a decision because there's too much in flux here that we don't know at all.
Anyone else?
I would either make that motion or second that motion. I'm not exactly sure.
Don't do both, please.
Not exactly sure what Mike just said, but I think the best course is for us to defer consideration. Let me call that Mike's motion, and I will second that motion.
Well, if Luke wishes me to rephrase that in a way that makes more sense, I'd be glad to. Beg your pardon?
The answer is yes.
In a short motion.
I make a motion that we currently defer any decision with regard to rezoning until and when we have additional information with which to make a decision.
There is a second, Ms. Hunter?
I second.
Any discussion? Yes, sir.
Just one thing that I think would be helpful for us. It's very difficult, based upon an old, 2010 zoning plan, to really understand what's going on. And I think we ought to have an area plan that is, very detailed, that shows us exactly what's going on around this whole
I was
discussion.
going to suggest that because what we have now is a boundary survey. I understand that there aren't specific requirements. In fact, there's not even an application for rezoning. It can be as simple as a letter, which is what this is. But if there was a plot plan that showed the houses, the actual adjacent properties and drawings of where those buildings were located, that would be very helpful.
If I may, I
Yeah.
have the access to the cities and counties' GIS information available right now. I could put it on the screen, or elsewise I can prepare a paper copy that we can distribute.
Why don't you do that?
I think that'd be the best.
Can do.
Anyone else? Yes, sir. Mr. Stockdale.
Yes, I just wanted to ask a clarifying question about the motion you just put forward. When you talked about more information, that was more information related to the proposed plans for the site, the mitigative efforts that could be agreed on among the community members, and particularly some of the issues related to access. Is that correct? Just to
Yes, I believe
clarify,
so.
thank you.
All right, are we prepared to vote? There's been a motion to defer. All in favor?
Aye.
Aye.
All opposed? We will defer it and let you know about the next meeting. Thank you so much for your presentation today. Yeah. Let's take a 5-minute recess so we can collect all our papers here and make sense out of this, please. Thank you.
That's why I think the plats
Yes,
will
thank
help.
you.
I live
Members of the Planning Commission,
house here.
We only have 45 minutes.
if we can, let's reconvene to continue our deliberations. Mr. Strange.
An iron fist. You gotta watch her.
I assume it is, yeah. I agree.
I'm ready to get on with this train wreck.
All right.
Yep.
Next matter that we have is the consideration of a concept review for One Rehoboth. And I believe Mr. Robertson is here as counsel.
I am, thank you. By way of introduction, it's good to be in front of the Planning Commission again. I see some familiar faces and some not so familiar faces, and it occurs to me this is the first time I've been back here, the Planning Commission, since we're all actually in person, which is very nice, instead of looking at the Brady Bunch on my computer screen. But I am Vince Robertson. I'm an attorney with Parkowski, Girk, and Swayze. We're a statewide law firm. My office is down here on the highway in Rehoboth Beach. We are here for concept review, and we're going to keep this fairly high level. As I think most of you all know, sort of concept review is the broad review of this. We know that with this particular project, we're going to have to go to the Board of Adjustment for one variance. Depending on the outcome of that, then we have to come back to you all for site plan review. And as I talked to Chairman Bryan, we realize that involves what I call the car wash of all the state and local agency reviews. That means Fire Marshal, DENREC, Conservation District, the city's public works folks, you name it. So we know we have to do that. So we're going to keep this at a fairly high level. And we do appreciate the opportunity to do this concept review. I am here still this afternoon with Jeff Gosnier. He's here from Grottos. Grottos is the lead on this project. We have Jonathan Silver in the back with the Onyx Group. And then we have Dave Grayson in the back from GGA. He is the contractor who will hopefully be building this project. And then to my right is Wally Funk. He is the architect of this project who's flown in from Chicago to speak with you. He will do that after I speak and answer any questions. The site is a hotel and retail sort of restaurant project. It is owned by One Rehoboth Avenue LLC, which, as I mentioned, is a Grottos entity with financial backing from the Onyx Group. I think I think everybody in Rehoboth and probably people far and wide are familiar with this site. I have this first slide up here, but just to kind of go over it so you can orient yourself. On the north end, which is on the right side of the project near the existing lifeguard station, is the current Grottos. It's a stucco building that was built in the 1980s or 90s. I'm old enough to remember when next to it was Dentino's Mini Golf, and there was a Dentino's Beach Shop on the corner. That's how far back I go back. So it's changed at least once since then when Grottos was built. And then next to that, we have what was Nick's Luncheonette. That's now closed. Next to that, at least it was open this summer, was an arcade, Zelke's Arcade, where there's still 10-cent skee ball. And if you get a certain score, you can get a nice pink T-shirt from them. There is the former Dolly's building on the corner. And then the anchor sort of to all this is the Sirocco Motel, which is in the rear of that Grottos building, Nick's Luncheonette, and next to that arcade building. It is a 2-story, well, maybe 3-story if you count the parking underneath, building that is uninhabitable at this point. I know there's been conversation, I see Matt Janis nodding his head over there with regard to the condition of that building. It has structural issues. There's fire safety issues that we need to remedy with it. It's not occupied. It hasn't been for some time as this project moves forward. And it's also not ADA compliant, even if those other things were brought into line. So it is a true hodgepodge of all sorts of different uses of buildings. We have wood, brick, concrete, stucco, and other things out there. There's also nothing on that block that, at least in my opinion and Mr. Funk's opinion, that has really any architectural significance at this point. So with that, the next slide is just the same block from a little bit different angle. You can see obviously the bandstand on Rehoboth Avenue. You can see the Dolly's building, and it looks back sort of at that quadrant of the city of Rehoboth. We'll get to in a moment. It also shows the development behind this property. So this is a totally new project. I'm going to ask Wally to get into the details, some of them. I'm going to hit some of the highlights first just to sort of set the stage for what this is, since this is sort of the first time formally that we get an opportunity to present anything to the city and the public with regard to it. We are looking to construct an upscale, modestly sized boutique hotel on the property with appropriate pedestrian-friendly retail and restaurant space at Rehoboth Avenue and the boardwalk level. With regard to the hotel, it will only be 60 rooms. We sort of did a brief study on that, and it actually is the smallest, or will be the smallest hotel on the boardwalk in terms of the number of hotel rooms on the boardwalk. It will have underground parking, and it will maintain the presence of one of our town's iconic businesses on this corner. As you know, Dolly's was there for decades. Grotto's is looking to relocate to the corner of Baltimore Avenue and the boardwalk, to this corner of Rehoboth Avenue and the boardwalk. Above the restaurant and retail space, the rooms are stepped back to create greater setbacks on all three sides. And as you'll see on that, you can see it on that one as well as the photograph I showed earlier, the facade is broken up. There's different types of materials used for the facing of the building, and you can kind of see designs and roof lines. It's also broken up with windows, doorways with transom windows, and there are individual balconies. The mansard-style roofs will also add character to the project, and I would say just if you kind of imagine that and then flip back to the original one, there is much more uniformity with what we've proposed, and I think it adds much more character and an improvement over what is currently situated on that block of Rehoboth Avenue, between Rehoboth Avenue, Baltimore Avenue, and the boardwalk. On the pedestrian level, the restaurants and other commercial areas will have garage door style fronts, and I'm sure that's probably the wrong word to use, Wally, I don't know, but that's what I call them. I guess it goes back to my days working at Funland when we had to roll up the garage doors. I don't know, that's what I call them. But it creates a sense of openness and accessibility to all those retail uses on that first floor. And mentioning Funland, it kind of reminded me of that. If you think about when you look at Funland from the boardwalk or Delaware Avenue in particular, if you look across it, for example, if you're coming through next to the Royal Treat and looking across at Funland, there's a sense of openness because of those garage doors along Delaware Avenue, and certainly on the boardwalk. Well, that's what this look will achieve because there's not windows and doorways. It's going to be very open and accessible to the boardwalk. Again, that will provide greater improvement over the access to what currently exists for all those storefronts. One other thing with regard to the businesses in this block, the delivery access will change. I'm going to get to some of the other businesses because I know there was an email about that. All deliveries will be from Baltimore Avenue, so there won't be, like there was in the case of Dolly's, deliveries on Rehoboth Avenue. I think Nick's Luncheonette also got deliveries where they would park in those loading spaces at the end of Rehoboth Avenue and then wheel their stuff down to the Luncheonette, probably the same thing with the arcade. That won't occur anymore. That's all going to be backloaded with an entrance from Baltimore Avenue. The hotel guests will also enter through an access on Baltimore Avenue as well. The hotel will have a pool. In this case, the pool is a necessity in Rehoboth. Again, by our estimations, all but 2 hotels in Rehoboth have pools. And based on market studies, it does appear that it's a necessity to be competitive and provide the amenities that hotel guests coming to our town expect. And that's particularly the case for a more upscale boutique-style hotel like this. I do want to use this one as an opportunity. I don't know. Yeah, there we go with the mouse. There was an email, it was in the correspondence section of tonight's agenda that dealt with the alleyway. That alley currently runs between Dolly's and the Core Brothers building, and it provides access to the back of Louis', Thrasher's, and I think 1 or 2 of the other businesses there. That alley is going to stay and actually gets moved next to Thrasher's, which is a little bit better. Wally will be able to show that on a site plan, but you can see that alley then, it comes around the back, I guess, or the the east side of Thrasher's, on sort of in between there, and then comes back behind Louis' and Thrasher's, and then those other commercial businesses that back up there. So that access way is being maintained, and I just wanted to take that opportunity to explain that since it shows up well on that picture. As I mentioned, the pool will be located in, again, to use a non-engineering architectural term, sort of the donut hole of this property, because our property extends back to the interior of this block. So there's properties of other ownership here on Rehoboth Avenue. Then we have the Admiral Inn back here with their pool and their parking. We're tucked in behind that with this proposed pool. So it won't be visible from anybody on the boardwalk, Baltimore Avenue, or Rehoboth Avenue. That is a small outdoor amenity, but it's one that we have determined is a necessity compared to particularly all the other hotels, as I said, except for 2 that we can think of that have pools within the city. The next thing I wanted to talk about, we have really had a high level of cooperation with the city on this project. As you all may know, the city's looking to completely redevelop its lifeguard station at the end of Baltimore Avenue. When we learned about that from city staff, we had a meeting with, actually we had a couple meetings, but we had a meeting with them to try to coordinate this project and make sure everything lined up well with it. That was actually a meeting with Mr. Miller. We had Davis, Bone, and Friedel there from the city's engineering architectural firm. Kevin Williams was there from the city's Public Works Department. Mr. Mendelis was there, and then our team was there. And we went through the plans for the end of Baltimore Avenue as well as the lifeguard station, our plans, and the access to both. So I don't have a plan of it up here, but a little bit of background. On the back of that lifeguard station, Baltimore Avenue, that streetscape, is going to fairly materially change based on the city's current plans. The pavement won't go quite as far, and there's going to be a lot more green space on the back end of the lifeguard station, which I think is a really good improvement at the end of Baltimore Avenue. But that put a wrench in our plans because that meant that the access into this building where we thought it would go couldn't go. So yeah, and in the record, you all might have seen there was an updated set of plans that were submitted to take that into account. But that will, I think, be beneficial to both the city and to our clients. The one thing, it creates an issue of necessity with respect to grottos, because if you go back to grottos over here, this is the current grottos. A lot of this back here, almost to where the Sirocco is now, is being redeveloped as sort of a single entrance sort of way into the Atlantic sands with a lot more green space back here. So the plans that we saw from the city virtually eliminate any direct delivery access to grottos at all. It really changes. If you're familiar with this sort of entrance to the boardwalk on Baltimore Avenue, that's at a real steep grade right now. I don't think it's ADA compliant. Matt's shaking his head, which is part of the change in the lifeguard station. But to do that and improve all that, while it's great for the city and the lifeguard station, and it's good for our project, it's really bad for grottos where they are now because it totally changes their ability to get deliveries and to have entrance into their restaurant with those changes. The good news is, in speaking with the city, we were able to accommodate all that with both design teams. The other part of this that I think is fortuitous in these discussions is that we were able to have real preliminary level discussions, but conversations with the city's team about the timing of all this. One of the things that I think everybody agrees is good for not just us in this room, but the city in general, is to mitigate the disruption on Baltimore Avenue as much as possible, because there's a lot of construction that's going to go into that lifeguard station. Keep in mind that in addition to a lifeguard station, it's also one of the public restrooms on the north end of the boardwalk. The lifeguards operate out of there daily on during the summer. I understand there's going to be meeting rooms and a museum in there. There's going to be a lot of upgrades, not to mention the work that's going to be done on Baltimore Avenue in terms of changing that streetscape. We're going to be doing the same thing. So we had really good conversations about how to stage that so that this occurs all at once instead of happens once, everybody starts driving on Baltimore Avenue, and then it happens all over again. So anyhow, the timing of all this was really fortuitous in terms of being able to coordinate both at the same time. This project actually versus what's there now will also have a significant benefit to the safe operations of the lifeguards. The new lifeguard station, you can kind of see it here. Let me go to this. There's actually, that sort of sticks out on the front, there's an observation platform or windows. I'm not sure what they exactly call it. But the idea is that from there, you'll be able to see northward and southward on the boardwalk, and more importantly for the lifeguards on Rehoboth Beach. And you can get a feel for it on this picture. Right now, Grotto's is here. Actually, let me go back. So this is where that lifeguard station is, and it's going to have that observation post here. We've got Grotto's here that's going to be right in the direct line of sight to that lifeguard station. Then we have the former Dolly's building down here that's built all the way to the property lines. So visually, that's going to be an obstruction as far as the usefulness of that observation post. But if you go to that picture in particular, you can see that this new building, as required by code, is going to be stepped back on the second, third, and fourth floor. So there's going to be a much better view shed southward down the boardwalk and towards the beaches from that observation station on the lifeguard, their observation post on the lifeguard station. The same holds true with regard to the view shed at the end of Baltimore Avenue. Again, if you go back to the current configuration there, the Sirocco Hotel is built to the street line. It blocks the view, and then we have the Grotto's cupola right here. That lifeguard station is going to be right there, and that's a narrow sort of view shed once the lifeguard station's built with these existing buildings. You'd be blocked. We have the Admiral behind it, which we can't do anything about, but you're blocked by the Sirocco and you're blocked by Grotto's. With this design, that really opens up the end, at least on the south side of the street, because there's much greater light and air that comes through between the lifeguard station and between our hotel there, that I think will really improve what you see after you turn on First Street down to Baltimore Avenue. And I would add, too, that really we get the same thing. Let me get back to a good one. On the Rehoboth Avenue side as well, although it's less significant because you don't have the two-story lifeguard station over here, but the same holds true on the Rehoboth Avenue corner of this property, because recall Dolly's comes all the way out to that property line. Again, you still, sort of like the Admiral Building, you're still faced with the Thrasher's building that's not going anywhere, that's built out of the property line, but at least ours will be stepped back further than what we have on the second floor of Dolly's. I'm not going to go through it all, but on the third page of the plans that we submitted, and this was something that we had a conversation with the city about, was the best way to present it, at least for, well, the whole way through the process. You'll see the chart of all the significant zoning code requirements. We are compliant in every way but one. I saw that our planner, or your planner, had said that for the most part we're in compliance as well. And I know we have to, again, go through site plan and everything else. It's really going to get a good crack at that. But we just missed it on the one, which is the FAR. And I would like to point out that in calculating the FAR, and I'm sure Mrs. Gay is thrilled about this, we're counting all the balconies. So anyway, we're counting. I know. We go back a ways on the balcony discussion. So, and we count all the decks and of course all the floor areas. There are several factors that contribute to this. What we hope is a minimal FAR increase for a commercial property. This is a building, I think we've sort of thrown around the term mixed use, and I know mixed use has a special connotation in the code. That's really residential and commercial. This is more of a commercial building with multiple permitted commercial uses in it. So when you do that, that sort of creates the need for additional FAR. And I'm going to sort of deconstruct that a little bit. If there was just a hotel on this property, on this, I think one of the most predominant corners in Rehoboth, with no restaurant or retail, there wouldn't be any pedestrian use or access. It would essentially be a big block of a building with, that would be closed off to everybody except for the people that are guests of it. What comes to mind, although it's not a hotel, is if you think about the Edgewater house that's a block or two up, that's condos, but that's the same sort of building. I mean, there's no retail, there's nothing on the front of that building that invites people in or says, this is a pedestrian-friendly boardwalk. It's a creosote railroad tie bulkhead and then units above it. Nothing against the Edgewater house, it is what it is, but I don't think that it's good planning to have that sort of structure that's blocked off to the public and not inviting right there on that most predominant corner of Rehoboth Beach. Likewise, would you do just commercial? And that also doesn't work. We can get into it later if we need to, but one-story commercial is all that really is viable. Two-story commercial, particularly in a location like this, just isn't all that viable. You look at all the properties around there, they're all one story. You think of First Street Station, that's never really been viable on the second story. There's a restaurant up there, but it's changed hands 3 or 4 times, I think. You know, so to make it work, you can't just have commercial on that property. It's not economically viable, and it's not really viable from a planning point of view. You know, it would sort of, you get up to the end of Rehoboth Avenue and the boardwalk, and if you had a one-story commercial, it would be anticlimactic in terms of what you get to at the end of our main street in town. So what that leaves us with is a mixed commercial building, again with a hotel and retail restaurant underneath. To do that, though, that requires a bit more density and FAR. And I'm not asking you to approve that because I know we got to go to the Board of Adjustment for that, but just to give you some idea of what we're thinking about on that. When you have a combination of those two uses, sort of the ancillary aspects of both cut into what you need to do for the FAR. For example, if you have commercial or retail or residential use, you have to add space for storage. You have to add space for big walk-in refrigerators. You have to add space for kitchens and things like that. So we have to accommodate for that. On the other hand, with a hotel, you have to add space certainly for the parking. In this case, we're doing it underground. You have to add space for the lobby areas and the amenity areas. One of those is the pool and pool deck, and although this one's fairly small, that pool deck itself counts towards the FAR. It's, as Wally can say, I think the way you describe it, it's actually hung from that top floor where the deck is, but because there's space underneath it, and that's an oversimplification, but that's the idea, there's space underneath it, because there's space underneath it, that counts towards the FAR as well. So you can see when you start calculating these types of things with the restaurant uses, the retail uses, the hotel uses, it bites into that 2.0 FAR really quickly, and it justifies, at least in our opinion, justifies the need for a FAR variance. The other, of course, is the balconies, and that's been a point of emphasis the whole way through on this, because unlike the other hotels and condominiums that you see well, let me back up. We wanted the balconies to be designed the way they are with single balconies so that it's not one big block of a building. You know, if you take those balconies off and reduce the FAR, you end up with a wall with windows in it. And I don't think anybody, we do have that to some extent on Rehoboth Avenue. You can see where those 3 rows of windows are next to Thrasher's. I don't think and that's part of the design with hallways and things, but I don't think anybody would like to see that same look fronting on the boardwalk at all. So we've mitigated the FAR, but we've also broken up the facade by having individual balconies on the rooms that front the boardwalk. And again, we realize that we'll have to go to the Board of Adjustment for that. We do also think that the size and scale of this project is consistent with the north end of the boardwalk. You can see in this picture what's developed around there. Some of those other projects sort of working up from this one are the Atlantic Sands. We have the Admiral Inn to the rear. We have the Edgewater House, as I mentioned, again to the north of that. We have One Virginia Avenue a little bit further up. And then we have the Henlopen Hotel and Condominium. We also have Patrician Towers, both One Virginia and Patrician Towers and the Henlopen. They're actually all taller than this. But the other thing is I think this is a much improved design to all those, and I don't intend to throw those buildings under the bus, but if you look at those, they tend to be just big block structures with gangways of either walkways or balconies all across the front and back frontage of them. There's no real architectural design features to them. Again, not an architectural term, but kind of blah looking. And they all look the same. You know, there's not any, to me, there's not any creativity that's involved. And we've tried to do right the opposite with this one by having, again, the different roof styles, the different siding on the outside, the windows with the transoms, as well as the awning over the retail and restaurant uses and those garage doors. So it's inviting, and it has some design features that make it unique, really to the north end of Rehoboth and its boardwalk. Sort of the last thing I want to touch on just briefly, and it's been talked about some this evening, was the comprehensive plan. As we've been going through this process, we were working mostly under the old one because the new one had not been adopted yet. But throughout both plans, frankly, they strive to, well, the older one really, and the one before it, wanted to get Rehoboth Avenue and that streetscape improved. And of course, we all know that the Main Street program did that, and that's been a vast improvement to Rehoboth Avenue. So I guess the most recent, before the one that was just adopted, comp plan, wanted to do the same thing for Baltimore Avenue and Wilmington Avenue. I would say that Wilmington Avenue, that's largely been achieved. There's been a lot of redevelopment on Wilmington Avenue. We have the Avenue Inn, for example. That's one that's been redeveloped, and some of the other properties on that street. I would say the same things are true with Baltimore Avenue in the second block. It's been redeveloped. There's been a lot of improvement. There's been a lot of investment in that with new restaurants or improvements to existing restaurants. This block has been somewhat the last one to be addressed, and I think that between the lifeguard station and this proposed hotel, it goes a long way, the hotel and the retail, it goes a long way to improving or in furtherance of the goals of our most recent plan and the one that we're currently going to be working under going forward. So we hope that you get the impression that this is a good, well thought out project. It's one that we've really been in a lot of coordination with the city already about, just in terms of their lifeguard station, in terms of the street design for Baltimore Avenue, how that impacts their project and how their project impacts our project. And with that, what I want to do is turn it over to Wally, again, to keep it high level, but to go through some of the more details of the site and the architectural rendering. And Wally, give me 1 second. I'll pull that up for you, hopefully. There we go. Thank you. Get my stuff out of the way.
Thanks, Vince. Hello, everybody. I'm Wally Funk with Noor Architects, studio manager for hospitality for Noor, located in Chicago. Vince went through a lot of the architectural stuff already, so he saves me a little bit of that. But just to kind of revisit some of these things, you know, we were especially thoughtful about the massing of the building, breaking up the massing, the materials, you know, being very respectful of this, obviously being in a prominent location. I think one of the big things that Vincent mentioned, you know, more than once that we thought was important is to almost create a permeable storefront at this first level. So it's almost an extension of the boardwalk and you know, it augments the boardwalk as it exists so that it almost, you know, reduces any sort of interference with people interacting with the building. We felt that was very important. And then as you get up the building into the balcony areas, again, because the way we wanted to structure this with the individual balconies, we felt that not only broke up the massing of the building facade, it also helps to have a little more interaction with the guests who are staying at the hotel with the boardwalk again. Let's see. Oh, gotcha. Sorry, going too fast. Ooh, that's a fast one. This is just an overview of the site, and it kind of shows where that existing alley we talked about is located. And Vince touched on this, going through all the various ordinance requirements. Again, we have the variance request here in the calculation with the overall total square footages. I'll go into that a little bit more on a case-by-case basis with the floors. And this is the proposed site outline, again, with the lot areas of the individual lots, summarizing the total site area here, which is 21,161 square feet. So as Vincent mentioned, we're planning on a two-level parking garage. It's really more due to the height and elevation changes. It would be more of like a 1.5 level, still having enough headroom, taking advantage of the elevation change at Baltimore Avenue as you go up to the west. This shows the lower level. We would have 22 parking spaces planned down there. And as you go to the first level down, we'd plan for another 38 parking spaces there, which would give us a total of 60. And as you can see here at this level, the ramp would come up and go out to Baltimore Avenue on the north. On the first floor, from Baltimore Avenue, you see we'd have this ramp here. And this was where we had the discussion with the city regarding the lifeguard station access. We had to rearrange this slightly in order to shift that to the west so that we'd have access coming in here. It didn't affect much on our plan, except we had to reconfigure the loading. We actually lost one parking space in the planning of that, but it works out well with the grades and actually even where our main lobby is going to be located off Baltimore down here. So the way this would organize is we'd have our entrance for the parking garage here, we'd have a hotel lobby here, and then the retail restaurant area would be oriented all the way around towards the front of the boardwalk, returning on Rehoboth. And then also, as Vincent pointed out, we'd have an area back here, which is actually under the pool area that you saw before. And as you can see here, we've broken out the different areas in terms of the FAR calculations. And covered area also included in the FAR, even though it's actually open to air. This would be that alleyway that we talked about. We would have a cantilever above, over that alley area, but we still maintain the access and then have this going east-west as well. Moving up to the guest room floors. On the second floor, because this is above the retail, we don't have technically balcony area there. What we plan to do is have a little bit more generous outdoor walkout deck. And again, that's a little bit larger than the balconies up above, but we would also count that, as you can see here, against all the floor area calculations. On this floor, we have 16 guest rooms. We'd have amenity spaces located here on the back, adjacent to the pool deck. And again, that exists back in this enclave that would be bordered by the other properties and the other buildings back in the back, but creating a nice little private area away from, the public sides. Both good for the guests, honestly, and also good for the public, kind of having that secluded away. And we would plan to do that sort of walkout area as individual to the rooms, but yet it would wrap around the building, so you'd still have some activation of the facades on the Rehoboth and Baltimore. And moving up to the third floor, we have 22 guest rooms on this floor, and you can actually see the setbacks occurring here as we go up too. And these would, as we had discussed before, these would have these individual balconies for each guest room. Again, wrapping around here, the rear handful of rooms would not have balconies. We would probably do just a Juliet balcony back there. Again, that's why we don't show the FAR calculator for those. And then the fourth would be identical. We'd have another 22 guest rooms on the fourth floor, so a total of 60 guest rooms overall. And then these are conceptual sections showing just the arrangement of the various uses as we go up and down the building with a lower level parking area. And you can see here we have this transition with a little higher elevation at the parking entry, which is going to enable us not to go down quite as far as we might normally have to. One of the things you can see here clearly are the step backs as you go up per the ordinance requirements at the angles here and here along both Baltimore and the boardwalk in Rehoboth. And then moving into the elevations, this is the one we had at the first screen. Again, sort of reflecting our different massing design we had going on here. As Vincent mentioned, we're looking at siding material. We understand that the building has to be non-combustible as a whole, so we're well aware of that. As the design progresses, we'll be incorporating all those features. This particular elevation on Rehoboth, you can see here again, emphasizing that sort of permeable storefront type of approach where we'd have the overhead, operable windows that would be able to just be popped open on nice days and just really create a much nicer, boardwalk feel even within the building. And this would be the rear elevation with the pool actually sitting on the second floor here. And then at the Baltimore elevation, this would be our entrance into the garage loading area. This would be screened off where we'd have any sort of back of the house functions that need screening, trash, et cetera. And then the main hotel entrance would be right here off of Baltimore. And then this is the shot from grade level, the view from the Rehoboth side, I guess 4th of July. But I was going to say, the lines would probably be a little worse. Yeah, right. But you can see here again, just emphasizing how we're really trying to develop this indoor-outdoor, just extension of the whole boardwalk feel, and then also with this sort of approach of the balconies and the decks, the massing here being, having a nice rhythm to it, being in keeping with the vernacular, we see around here. We feel like it works really well with this location. And this is a slightly skewed version from the north, looking down as well. And again, using the same sort of idea all along that boardwalk side. And as Vince had said, focusing on the Rehoboth side, the boardwalk side with our main retail, public functions. The return side would then have on Baltimore would then have our service, back of house, access, loading, and then also the hotel entrance. Oops, I think that might be it, huh? Oh, no, I think that's it.
Thanks, Wally. I appreciate that. I don't know if anybody from our team wants to add anything to that. Okay. Well, with that, we'll open it up to any questions or conversations we need to have at this stage. So thanks again. We appreciate the opportunity to sort of roll this out to the city for the first time formally, despite the meetings we've had already with staff. Just for example, we didn't want to bring a plan that we knew was a non-starter in terms of the coordination with the city on the lifeguard station. So it's thus far been a really collaborative effort in that regard. So again, knowing that we've got a lot more work to do, we'd entertain any comments that you all have at this point, constructive or
Do you
otherwise.
have any plans for, or do you have your schedule for when you think you might seek a variance before the Board of Adjustment?
So we don't, because at least last I heard, there's not a full board. When Mr. Capone had resigned, that left us with 4 members of the board. And as of last week, there was still only 4 members. Is there? When I checked with the city, has there been a 5th person that's been appointed in?
They were at the last meeting. One was absent, but I mean, since there's 5.
Oh, all right. Well, that's different than.
One was absent at the
Right, yeah.
Oh, all right. Well,
They've been
maybe.
in place for a month or so.
Okay, because I was told that there were only 4, and maybe that was referring to that meeting.
Yeah.
So, with that in mind, as soon as we can. So we were just waiting on that. This is a big enough project. We didn't want to go through the board without there being a new appointment with Mr. Capone having resigned.
Now, before other questions from the members of the Planning Commission, I have today given you 2 basically memos from Wallace Montgomery, the engineering firm that advises the Planning Commission. And those outline a number of topics that certainly Wallace Montgomery believes are issues to be addressed, and I believe the Planning Commission will feel the same way. And they vary from fire safety and emergency access, parking, underground parking, imagine that.
Yeah. And we know and just 2 points on that, Mr. Chairman. One is we know one of them dealt with FEMA, and how we construct the garage. And certainly, Mr. Funk is prepared to go into all the details you care to hear about FEMA and how to design an underground garage, but that's putting the cart before the horse a little bit at this stage. So we recognize that. The other point is, and this may have been a miscommunication on my end or Mr. Janus's, we only got the November 9 memo from Mr. Janus. Not an issue, but if you could email that out, or somebody could, to us, so we have that.
He certainly can take care of that, and if not, I have it here as well.
Okay.
But yes, I think it would be very helpful if you would respond to the issues raised by Wallace Montgomery and proceed for your variance before we get too much farther into this project, and then come back to us. My thought is, subject to what the members of the commission thinks, is that we will continue this for further consideration at a future meeting or meetings, And the code talks about us having meetings or meetings. I mean, it says that this is kind of an ongoing process. And we're looking for a lot of information from you to address the issues that Wallace, Montgomery, and the other commissioners may have.
Chair, are you saying they would come back for another concept discussion
Just we'll
before
continue
some of
this.
these other, okay.
So that just, and I think I'm on the same lines as
Yeah.
you. Does that mean that we should go ahead, because you asked about the variance, I'm inclined to go ahead and apply for that to get that process started.
think you
Okay,
have
I just wanted to make sure, yeah.
Yeah, I mean, to me, there's nothing to talk about until the FEMA issues are addressed and the FAR issues are addressed. Other than, all bets are off otherwise.
Well, and that's always the difficulty in one of these things, because it depends on
Yeah.
who you're in front of. You know, if we're in front of you all and we need the Board of Adjustment, you know, you sort of say, well, why are you here? You don't have the variance, you know, and if we go to the Board of Adjustment, it depends on, it's a chicken and egg situation. The FEMA issues, we will certainly talk about those, and we're prepared to do that. I don't want to oversimplify it, but we've got to comply with what FEMA says, you know? I mean, we do, and we don't want to jeopardize the city's flood insurance or anything else like that. I mean, that has to happen. Mr. Janis and his team are going to make sure that happens. You know, I would just say that don't expect necessarily a lot of detail on that till we get to the site plan review stage, because that's typically when that would come out. I mean, I'm not trying to hide it, but, you know, I don't want to, I just want to keep things in the right order.
I thought there were some no or go-no elements in that, though. You know.
If I
Please.
might interject real quick.
Please.
So a couple of things. For the November 9th memo, it anticipates that it will be premature in the process to address all of these, you know, right now. So please understand that I'm available at Mr. Bryan's discretion to discuss with you guys at any point, any of these comments and others that come up in the future. Obviously with your blessing. I think that some of these are, I won't characterize anything yet as a ultimate sticking point. More so recognition that there will certainly be some red lines, if you will, that as you're well aware, FEMA won't generally permit us to permit.
Understood.
And as your design is further along the path, those should be much more clear as to how, you know, your attempt to address those is shaping up.
No, understood. I think we're all saying the same thing, speaking the same language, and I think we'd welcome the opportunity to speak with, you know, our team and not me, you guys, on the technicalities of, you know, what's required for construction and FEMA compliance as well. And I'm not trying to gloss over it. There's been a lot of time spent on that with Wally and his team, and we've looked at the FEMA maps, what we need to do with that, and how that affects whether we get a map amendment, and how we build that underground garage. There's been a lot of involvement. It also, frankly, affects you know, the access potentially from the first floor level of the retail to the boardwalk. And that would impact the ADA issues, you know? So, I mean, these are all things that we have spent time looking at it. So not trying to diminish the importance of it or the amount of time that's already gone into it. We're just at such an early stage that that's maybe a step or two down the line, so. Yeah.
I guess a general question or two for the underground parking particularly. Do you anticipate having to deal with groundwater in that? Yeah.
That's you question. Yes.
Yeah.
Yeah, absolutely, right.
So in, you know, general terms, what are your thoughts on dealing with that?
I mean, there's going to have to be, I'm sure there's going to have to be, I mean, I'm not an engineer, I'm an architect, but I'm sure there's going to have to be, you know, some sort of pumping, you know, system that has to occur. I would think there's no way around it, even if it were a single level, to be honest.
Right.
And extensive waterproofing, you know, which we're accustomed to. And, you know, I think, you know, we're aware of all that. And it's a specialized level of detailing and, you know, but whether it's one story or two, you know, you do the same thing is really what we're going to do.
I think part of the difficulty is that you're going to have a sort of not conflicting purpose in that you need to remove the water from as it's seeping in, but also have a design that encourages groundwater to seep in order to address the non-transference of hydraulic energies.
Yeah, right, exactly. Yeah, there's actually, that's exactly right. The structural component of this is important as well.
Yep.
Yeah, that's another issue with this too.
And of course, we're not going to get into that stage until we're near to
Correct.
the building
Yes.
plan stop,
Right.
phase. So yeah, that's a while off.
Yeah.
Now, the second series of comments from the 11th that you don't have, my apologies, I'll make sure to get those to you. Absolutely. And where did I just put them? I had them open here a second ago.
I saw it close down.
We'll talk about that.
And we could certainly talk about that offline as well.
Absolutely,
Right.
absolutely,
Yeah.
and, yep.
Right, absolutely. I definitely have to do that.
And I would just say, you all may not realize it, but there is underground parking, or, well, not parking, space that exists on the boardwalk now. I'm not sure about the Henlope, and Matt, you might know Edgewater House, but I know actually it's not parking, but Funland has, underneath all the rides, that's actually underground storage for all their stuffed animals. It's kind of a zoo under there, literally. But and they really don't have a water issue there. But it again comes down to mitigating the water coming in and the structural issue. So this isn't uncharted territory either.
Did I?
Well, I guess just in
adequately-
addition, if I can make a comment about in addition to all of the FEMA things, that one of the things in the planning report was just a sort of note that on the zoning and proposed use, that we don't really have enough information yet to determine much of that information. You had a chart that showed that it was code compliant with everything except the FAR. I'm not sure that's accurate, and so that we will want to take a closer look at that. I didn't see. I think there could be lot coverage issues, for instance.
I think there are a number of zoning code issues that need
Okay.
to be
Well,
addressed.
again, we've designed it based on our understanding of what the code says. This is the concept plan review. As I mentioned, we're going to have to get the FAR addressed with the Board of Adjustment, and then we turn it over to Mr. Janis, and we're going to have a lot of conversations on, just to make sure it's compliance. No, totally understood. So, I would say though, if somebody could, this is supposed to be a constructive process. So if there are specific concerns that somebody on the commission has, we don't have to do them tonight, but if you could get them to Mr. Janis and then funnel them to us so that we're all sort of marching to the same sheet music and can sort it out, that would be really helpful to everybody.
I think you're going to find the memos from Wallace Montgomery helpful about that.
Okay.
And also, just as one other sidebar, I believe you need to, perhaps, unless you've already done this, have you consolidated all these parcels into a single parcel of land?
That I'll check on. I'm not sure. I know we have the survey that's the perimeter. If we haven't, that's easy. I didn't do the real estate side of this, so I can't speak to that, but I do real estate work. So if that's easy enough to do, because we have the perimeter survey, so it wouldn't be a problem to consolidate.
Just wanted to be sure that box was going to be checked.
No, that's a good
before we get too far.
And I did want to call attention, I'm sorry to interrupt, but to one specific error that I noted on the boundary survey plan. It referenced, oh gosh, let me find my right notes. It had the correct reference to the firm panel, but it listed, come on, where is it? Okay, so the note indicates that the subject site is delineated as falling within zone X and AE, but it's actually X and VE. And then, just to make sure you're aware, I think you probably are, but there is a LOMAR that covers the area immediately south of that. Included in the notes is a reference to that LOMAR.
Yeah, okay.
It doesn't appear to impact your parcel, but it's close.
Yeah, right. And there's been some map amendments on the south side of the boardwalk. So,
Yeah. And did I hear you guys mention that you are considering a LOMAR for this project? Yes. Want to keep your toolbox open.
Yep, now we are, which goes into the steps that we need to follow.
Right.
Great. Any other comments from the commission?
Mr. Chair, if I may, I'd like to, go ahead, Jim.
Go ahead. Well, on the technical, because mine is a soft issue.
Very good, thank you. Just a couple points to be mindful of. You may or may not know that we're currently doing some work on encroachments and license agreements, et cetera, for city property. Be mindful of those as you move forward, and until we get a solution to those and some kind of recordation process, they will hold you up So you may or may not want to include those on your plans at this time. I don't necessarily know if you have any encroachments, but if you are considering any overhangs or anything like that,
We're yeah.
very good.
I think Dolly's does now to some extent. I think those overhangs at the floor level,
Right.
or above the first floor, and we're used to. well,
Yeah, so
used
it's a
and that's going away. So yeah.
it's a greater issue that's been identified across Rehoboth, and we're trying to do some work
Understood.
towards that. Do you know, and I can't see, and I don't recall if there's any connection to the Admiral? I think it's, I don't think it's connected. I think it's pretty,
No, it's not. It's this like the Sirocco. There's sort of a ramp into the Sirocco from Baltimore, and then it's basically just a wall. There's no connection at all.
yeah, that's what I thought. I'd just
Yeah.
be mindful of that as well,
Yeah.
and be
Yep.
be a good neighbor. That's
Oh
all.
no, absolutely. Yeah.
Also be mindful of your pumping locations, so when you're dewatering that land, obviously you're not gonna be able to throw it across the beach or anything like that. Just be mindful of that. And then the consolidation might bring up another issue of through lots, which we can talk about offline.
I'm sorry. What?
Through lots.
Oh, through lots. Okay.
So, yeah, in our code, you're not really allowed to create through lots, but we can discuss that. I think it may need a variance or some kind of request on that time, or come before the planning commission to get that achieved.
That's surprising to me, just because of, I just think about, like I mentioned, the Edgewater House or the Henlopen Hotel or One Virginia, everything. I mean, even Funland, they're all one. Frankly, it seems like you would want that to be on the case of anything fronting on the boardwalk, to be one consolidated lot.
Yeah, it's just one of those obscure codes that are located in there that you'll have to have an answer for.
Okay. And I'm not sure. I'll look at that, Matt. I know that applies, and usually it applies in the residential sense, because just in terms of setbacks and what's the front and what's the rear, and here when there's 0 lot setbacks for commercial, we'll look at it. Yeah,
Right,
but thanks for
right.
pointing that
And
out.
I think your opposite corner there might run into the same issue, so you may want to pay attention to that to see what they do in coordination.
Oh, I got you. Understood.
Right.
Yeah.
That's it. Thanks, Chair.
I'll ask Mr. Dukes back there what's going on with that.
All right, anyone else?
Yeah.
Yes.
I'm sorry, yes.
Mike, I'm the architect on the panel, and I just wanted to applaud the architectural approach, which is to break this down visually. And I think you've done a very good job with it, and I would only encourage that as this continues to develop and be refined, that you continue with that approach.
Thank you.
Mr. Strange.
Yes, the only comment I was going to make, that the chicken or egg issue is very real between us and as Vince pointed out, between us and the Board of Adjustment. But what concerns me is that with regard to the FAR ratio is, and we were the ones that instigated this with the planning commissioners, was removing underground parking from the FAR. And if that had never been removed, it would have been very problematic with what you just designed, or you'd have to go to the Board of Adjustment to get a variance.
And it would have
But
been
the
a
Board
real
of
big
Adjustment,
number.
I'm
Yeah.
sorry, go ahead.
It would have been a real big number.
Yeah, and a real big number, but even though it's a smaller number, it's a self-induced issue. But what my concern is that, and there's no solution to this right now, is the Board of Adjustment only looks at 3 criteria when they make their decision. We look at north of 20 over a multitude of issues. And so, and I would agree that conceptually, from a visual standpoint, it's a pretty nifty looking design architecturally. But in just looking at the preliminary drawing, and I'm stating this as from the standpoint of being an engineer and an urban planner, there are some physicality issues internally within the building that are problematic, but those are going to come out by virtue of all the approvals that you have to get through other agencies. So there's no need for me to even go into it right now.
Right. I mean, I completely understand that. The big one's going to be with internal issues is, say, fire marshal, for example. They're going to want to see emergency access. They're going to want to see the size of the elevators, the size of the walkways, to make sure you can get in and out and turn stretchers around and all that stuff. And so, we realize that. And
Yeah.
it's either designed that way or it's going to have to be designed that way or they're not going to stamp it.
Right.
And that's one of many, but that's a good point.
I mean, it's that kind of thing that most people don't realize and don't see, and quite frankly, it's not related to my being an engineer or planner, but I was a firefighter for 13 years. And things that are not intuitively obvious to most people become very obvious when there's an emergency situation. And I can speak with great authority on this because I was almost killed a couple times because of the design of the facility. And when you run into a building when everyone else is running out, you have to be crazy anyway. But that's what happens. And so and I know some other members of the community who are property owners, this is an issue that's of significant concern to them. So anyway, just a
No, thank you. I
general
appreciate
comment.
that constructive comment.
All right, then, if we may, so I can summarize briefly, under section 23631 of the code, when we complete the concept review, the planning commission issues a report. We will not be doing that at this time since we have not completed our review, and instead we're asking for additional information as per the Wallace-Montgomery memos and the comments today. So we look forward to seeing you again with more information.
Sure, and just to clarify, so we know what our marching orders are, there's going to be the Wallace-Montgomery memos, which we have one of. I think we need the November 11th one as well, which I think will be helpful. There was some talk of questions about compliance, if those could be incorporated into either those memos or a third memo, just so we either make the changes or address them however we need to, whether that's through a look at the code or through other variances. That would be helpful to keep the process moving forward. And I just want to be clear that we're going to, even though we talked about the chicken and egg, we are going to go forward with at least getting the Board of Adjustment application submitted. I think it is submitted. Actually got pulled back or stayed when there was only 4 when we had that resignation. So I think all of those things accurately reflect what I'm hearing this evening, hopefully. Head nods. Okay. All right. Thank you.
All but the answers. That's what we're looking for.
No, understood. So, well, thank you very much. This has been it's been a good opportunity.
Just one
sure.
Just generalized question, Vince, because obviously you folks have put a lot of work in on this so far. Is assuming in a perfect world, other regulatory approval cycles follow patterns that you're personally familiar with. What do you think might be a timeline do you anticipate things might actually go through if they were reasonably?
So we with Dave Grayson, we actually and I have it back there. I don't know, Dave, if you know offhand.
Yeah, our target start date, we're trying to match up our target start date for September of 2023 to coincide with the start date.
Right.
The beach control. That's aggressive, but that's kind of what.
Well, that's fair. I just yeah.
And so I don't know that it got picked up on here. So the start date was September 2023, and as Mr. Grayson said, that is aggressive. But there was actually a good bit of time that Dave put in with Davis, Bowden, Friedel, and Kevin from the city. There actually is a bar chart showing, which I'd be glad to show you. I know I'm getting a head nod from the architect, but shows the construction schedule in terms of the design and approval phase, site work phase, everything else. Because what we wanted to do, as I mentioned, to the extent we can, is line this up with what the city's doing. And both of these are probably moving targets for the city on the lifeguard station and for ours. But we're trying to stay aggressive, and that's why I appreciate being able to go to the Board of Adjustment simultaneously with this, so that, again, we mitigate the upheaval on Baltimore Avenue when this gets done. Here's the bottom line on this is that a project needs to happen there because we have the Sirocco Hotel it's not even a hotel, it's a motel, and it's not even a motel anymore because it's boarded up. That needs to come down. It needs to. But there's issues with it coming down by itself because it's on the back end of Grottoes and you've got the Admiral right behind it and everything else. We've got Grottoes, which becomes functionally much difficult, if not impossible, to continue operating the way they operate right now with that lifeguard station and the Baltimore Avenue redevelopment and streetscape project that the city's doing. So we've got all these moving parts, so the extent we can kind of keep things on parallel paths with you, with the Board of Adjustment, with the city, on the lifeguard station, we're all going to be served better off. And I imagine, Mr. Chairman and Commissioners, what I can envision is we'll keep having conversations with you all, go with the Board of Adjustment, be doing concept review, and the concept review itself may just morph into site plan review at some point, just to keep things going. So we'll see. Maybe I'm overly optimistic, but we'll see. Yeah,
Thank you so much.
You're welcome. Thank you.
Well, our hard stop time just expired, and I will be glad to entertain a motion to adjourn.
So moved.
Second?
Second.
Anybody against it? We're adjourned.